Successive conflicts of interest, Part 1. Successive conflicts of interest are governed by Rules 1.9. Rule 1.10 deals with the imputation of these conflicts of interest. Successive conflicts of interest have similarities to concurrent conflicts and differences. One similarity is the concern for confidentiality. The rules will prohibit successive conflicts that could harm a client due to confidential information being available to an opposing attorney who should not have that information. However, the principle of loyalty is handled differently. The rules must balance clients' desires for confidentiality and loyalty with the attorney's need to make a living. Accordingly, once a client is a former client, the lawyer becomes a little more free to represent conflicting interests. The basic rule, set forth in Rule 1.9, is that the attorney may not represent a client in the same or substantially related matter in which the new client's interests are adverse to a former client. What does that mean? First, while one cannot both sue and represent a given client in real time, concurrently, it is permissible to sue a former client. What is not permissible is suing a former client in the same or substantially related matter. It should be obvious what the same matter is. For example, assume the criminal defense counsel has undertaken to represent two co-defendants and then a conflict develops. Let's say one client wants to plead guilty and the other does not. One client wants to blame the other client and argue that he was less culpable. As we have seen with concurrent conflicts, the lawyer cannot continue the concurrent representation. And, under Rule 1.9, the attorney cannot continue with either of the clients. If she did, she would be representing one client with interest adverse to a former client in the same manner. Another way in which the attorney cannot be adverse to a former client in the, quote, same matter is that the attorney cannot undo her prior legal work. As Comment 1 notes, the attorney cannot seek to rescind a contract for a new client that the attorney had drafted for a former client. The attorney cannot, for a new client, challenge the patent the attorney prosecuted for a prior client, and so on. Next, let's consider what is a substantially related matter that would preclude the attorney from representing a new client against the interests of a former client. The first thing to remember is that the two matters are, quote, substantially related when they are substantially factually related. See Comment 2. Let's consider some examples. The standard was initially established by the case of TC Theater versus Warner Brothers Pictures, where any substantial relationship exists between the subject matters in the two cases, the second representation is prohibited. The court will assume that during the first case, confidences were disclosed bearing on the subject matter of the second case. In the well-known case of Analytica, Inc. versus NPD Research, the law firm was hired by a company, NPD Research, to figure out a way to transfer stock to an executive, Malik, as additional compensation. To do that, the law firm obtained substantial information about the financial situation of the company. Then, sometime later, the executive, Malik, left the company and started a competing company, Analytica. There was a lawsuit between the departed executive and the company. The executive and his new company, Analytica, hired the law firm that had figured out the compensation plan. The former employer, NPD, moved to disqualify that law firm. There was no question that the law firm was representing a new client against a former client. The only question was whether the legal matters were, quote, substantially related. Obviously, they were not the same legal matter. The first case was a corporate case of figuring out a stock transfer compensation plan. The new case was an antitrust suit. But the court found that the matters were substantially related. They were substantially factually related because the confidential information the firm obtained in the first representation would be relevant to the second representation. In the first case, the law firm obtained information about the company's financial matters. This information was going to be very useful in the second case, an antitrust matter. The rule established in Analytica has become the interpretation provided in the rules. Matters are substantially related if the confidential information that would have been shared in the first case would be relevant in the second case. As Comment 3 reads, matters are substantially related if there is a substantial risk that confidential factual information, as would normally have been obtained in the prior representation, would materially advance the client's position in the subsequent matter." Close quote. In doing this analysis, courts have held that they will not inquire into what information was actually shared in the first case. Based on the nature of the case, the court will irrebuttably assume that the relevant confidential information was shared in the first case. One justification for this irrebuttable presumption is that the client should not have to reveal what was and was not shared in order to prevent her former attorney from turning against her on a possibly related matter. See Comment 3 to Rule 1.9. Accordingly, it is necessary for the attorney to keep careful account of the nature of each matter he works on. However, the court will look into whether the confidential information it presumes the lawyer will have gotten will or will not be relevant in the second case. Rule 1.9c further provides that a lawyer must not use information relating to the representation of a former client to the disadvantage of that former client. The attorney continues to owe the former client confidentiality. Does attorney equal firm? The short answer is, while attorneys stay in the same firm, yes. But if attorneys have moved into or out of a firm, then the answer is more complicated, and the possibility of representing clients with interests adverse to former clients is looser. Because the assumption is that attorneys within a firm share confidential information as appropriate to provide the best representation, there is an irrebuttable presumption that the confidential information that would have been shared in the first case was shared by the entire firm. There is no opportunity for a second attorney at the firm to take the case against a former client on the same or substantially related matter by showing that the second attorney did not get relevant confidential information. Here again, it is important for the firm to record the nature of the first representation so that it can be explored whether the new proposed case against a former client is the same or a substantially factually related matter. Attorneys in motion. When lawyers move from firm to firm, the possibility of an attorney or a firm suing a former client is more available. A good case to illustrate this scenario is the case of Silver Chrysler Plymouth versus Chrysler Motors. In that case, a young lawyer worked for a large law firm that represented Chrysler Motors. The lawyer handled a number of small litigation matters, removing cases to federal court, etc. Then the lawyer left the large firm and started a small firm of his own. At that point, he was retained by a local Chrysler dealership to resolve a dispute over its franchise agreement with Chrysler Motors. At that point, Chrysler Motors moved that the young lawyer be disqualified from representing the dealership. However, the court found that there was not an impermissible conflict of interest. The nature of the matters that the lawyer had worked on in the firm were unrelated to the franchise dispute that the new case presented. The young lawyer was not assumed to have all the confidential information that the former firm possessed while he was there. He was able to rebut the presumption that he had any relevant confidential information. See Comment 5 to Rule 1.9. Let us take the situation of firm A, B, and C, in which partner A handles corporate matters and has done corporate representation for Corporation X. Attorney A leaves the firm, and potential client P comes to the firm of B and C, seeking to sue Corporation X. If the matters are the same or substantially related, i.e., if confidential information that would have been shared in the first representation would be relevant to the suit against Corporation X, then firm B and C could not accept the case. However, Rule 1.10b provides an exception if Attorney A, who has left the firm, was the only attorney in the firm with confidential information about Corporation X, and if no one in the remaining firm of B and C has confidential information about Corporation X. Because of this rule, when firms reconfigure themselves, it is very important to take account of who has worked on particular matters and who retains, or does not retain, confidential information about a former client. Let us consider the other attorneys where a new attorney may bring a conflict into a firm he joins. Let us say Attorney D in his firm D, E, and F represented Mr. and Mrs. Z in their limited corporation business matters. Attorney D joins the firm of A, B, and C to make A, B, C, and D, leaving the corporate work for the Z company to be handled by E and F. Then, Mr. and Mrs. Z separate, and Mrs. Z approaches A, B, C, and D firm about representing her in the divorce. Is this possible? First, we should assess whether the corporate work for the Z's firm is a, quote, substantially related matter to Mr. and Mrs. Z's divorce. Yes, it is likely a substantially related matter because D would have had confidential knowledge about Mr. Z's financial situation, and this confidential knowledge would be relevant to the Z's divorce. For this reason, Attorney D cannot represent Mrs. Z. This is the situation covered by the rather confusing language of Rule 1.9b. But could other members of the firm represent Mrs. Z in the divorce? Today, given a recent change in the model rules, such representation is possible. Under Rule 1.10a2, the A, B, C, and D firm could accept the case if the firm had established a barrier wall or screening for new Attorney D when he joined the firm, noting all the matters which Attorney D previously handled. If when Mrs. Z comes to the firm, Attorney D is cordoned off from any involvement with the Z divorce, he has no access to confidential information, and he gets no portion of the fee from Mrs. Z's divorce, then his new partners, A, B, and C, are able to accept this case. The firm would also have to give written notice to any affected former client. Waiver. Recall that in certain circumstances, where it was reasonable, clients could waive concurrent conflicts of interest. With regard to successive conflicts of interest, clients can always waive those conflicts. Rule 1.9a provides for waiver by the client giving informed consent confirmed in writing. This is the conclusion of Part 1 to successive conflicts of interest. Please listen to Part 2 regarding successive conflicts of interest about government attorneys.